Thank you very much for the introduction. Thank you for having me. It's my pleasure to be here. I have family in the Bay Area, so it's great to be back. Let's just make sure this remote works. Okay, great. All right, we're working. Technology, got to make sure it works. That's what we're here to talk about today. So before I actually get started, I just want to get a temperature of the room. And I want to get a sense for technological preferences. So raise your hand if you love technology, you need the newest device, you're downloading the most software every single day when it gets released. Anybody? Okay, I see a handful of hands. Okay, right? Like you need to use the cool, fancy new software, right? All right, that's pretty typical for a legal audience. And again, I am a practicing attorney. I talk to lawyers all the time. Next, raise your hand if you like technology, you use it. Like maybe your phone is 2 or 3 years old, you update your software when you remember to, and you know, like you like Microsoft Word and tried and true tech, right? Yeah. Okay, all right, yeah. So probably half, if not more, of the audience here. And then the last category is, you know, technology, it's there. You know, I prefer a tactile experience to digital, and I couldn't tell you what model phone I have. Is there anybody like that here in the audience? Okay, all right, yeah, it's okay. So most of the legal professionals I talk to fall in the later two categories, and that's pretty common. Right? In particular, in the legal tech industry, they have a really hard time selling to lawyers because lawyers don't really adopt technology. That's okay, right? Like we are a profession based on precedent, and new technology has no precedent, right? But what I have found is that most lawyers who fall into those two categories, right? Your tech proficiency isn't necessary, or preferences, I should say, aren't necessarily something like you want to use tech. After they work with me or they hear my talk and they try the emerging technology for the legal industry and for every workplace, AI, generative AI, and I'll explain exactly what that is in the slides, they love it. I'm going to give you 2 reasons why. The first is, think of it this way. Well, let me ask one more question. Who here sends and receives email from human beings? How about text messaging back and forth with humans? Okay, let the record reflect 100% of the hands went up. That's the way that you interface with these tools, right? You just chat with it. It's natural language interface, as the technologists will tell you. I call it the English language. Who better than lawyers to leverage these tools? We are masters of language, right? Our trade is in words, right? That is the number one reason why lawyers who start using these tools love it and are leveraging it and find all innovative ways that they could use it. The second one is ChatGPT, the useful version of GenAI, because it's been around for longer, but it wasn't useful until ChatGPT was launched in November of 2022. It's been 2.5 years that this technology has been usable for a profession like ours to actually help us with the work that we do. It is a level playing field. You could be giving this presentation at the next symposium. You just need to be using the tools every day. The problem is that there's a lack of financial incentive in the industry, which we'll get to, right? So let's start with the presentation. I'm Matthew Kurbis. I'm a subscription attorney. I started my law firm in March of 2022. Notice it was before ChatGPT launched. But since when I launched my firm, I decided I was going to stop billing by the hour. It's part of the reason why I had to leave a practice to start a practice. I was already incentivized to find all the technology that was out there to make myself more efficient. Because when you're not billing by the hour, the faster the work gets done, the more money you make. So the less time it takes, the more money it makes. And almost always, that's more valuable for your client. The faster they get work product, the faster they get results. So I've been using AI since launch. It was not good in March of 2022. Machine learning based, if this then that type logic based AI, it was okay, but not great. And I was just trying to get my hands on every single tool out there, which meant I was there in November when ChatGPT launched. So I've been using it since day one. I don't have that much more of a runway than you if you have not used it yet and you start using it today. But I would highly recommend you actually not use ChatGPT, and I'll get into that. So since then, I've been teaching lawyers how to use it, how to ethically incorporate AI into your law practice, because we've all heard the horror stories. The lawyer for the My Pillow guy, right, very recently just got in a lot of trouble with this, right? He obviously hasn't taken one of my CLEs. I also teach lawyers how to adopt hardware and software. AI is like its whole own category, but it's essentially software, the way that we interact with it. My target market is the latent legal market, and I'll explain what that is if you haven't heard of it. And any show of hands for if you know what the latent legal market is? Has anybody heard this term? Okay, oh good, you're gonna be in for it. So here's what we're learning today, right? The implications of AI on billing time, the data I'm gonna introduce to you very quickly, data on the latent legal market and AI for legal services, how to correctly use AI, because at the end of the day, we can't just blindly use these tools, right? We need to be intelligent with the way we incorporate them and use the right tool for the right project, right? Imagine you hire a contractor to come to your home and they use a power drill to saw a 2x4. Well, if you're using ChatGPT to do legal research, that's like what you're doing, right? It wasn't designed for that purpose. And we'll discuss the most ethical way to bill clients when using AI. Now, obviously, no legal ethics advice is given in the presentation, just for educational purposes. So let's think about this. You charge $500 an hour, right? 10 hours of billable time makes you $5,000. GenAI makes 10 hours of billable time take 10 minutes. Now, what's actually happening is you get your results in seconds. But what you're able to do is you're able to iterate and iterate and iterate, right? Right now, you give an associate a task, or if you are an associate, you get the task. You go away for a few hours or a day or a week, and you come back with the task you were assigned, the legal research, the drafting, whatever. The partner looks at it, goes back and forth, and maybe you do that a few times. With GenAI, you're able to iterate within a few minutes and get to a high-quality work product in 10. So, under the billable hour, GenAI world, $5,000 is $100. And if you're not there yet, our clients, regardless of how sophisticated they are, they're going to start asking if they're not already. Well, I put that into ChatGPT and it gave me the results in a few seconds. And they're lay people. They don't get it, even if they have a certain level of sophistication. I think that's worse for the attorneys that are working with in-house counsel at corporations. But for the layperson, it looks similar. They don't know the nuance and the difference. They don't have the years of experience that we do or the legal education, but to them, it looks a lot similar, and they got it in seconds. Why did you bill 10 hours for this? I've got a question. ChatGPT is wrong. Right, but the layperson doesn't, the layperson doesn't know, right? The layperson doesn't have the education. They don't have the background. They don't have the understanding or the training, right? And I don't recommend you use ChatGPT. So what do? Right? Do you raise your rates? Right? Because that's like, if you're thinking logically, well, okay, well, it's just faster, so I'll raise my rates. Well, let's look at that. To make point 2 worth $5,000 means you need to charge $25,000 an hour. Okay? And I know lawyers don't like math, so I like to keep it simple with round numbers and stuff, right? So 5,000 times your billable rate, 50x, right? Would your clients be happy to pay that rate? Are they happy to pay your current rate? Right? Are you ethically allowed to charge that rate? Right? What does that mean for serving the latent legal market and access to justice? What are your options? Well, that's what I'm talking about today. So let's look at the latent legal market. Just in case you haven't heard this term, it sounds like nobody has. According to Grandview Research, last year, $400 billion was spent on U.S. legal services in 2024. Right? This is recent data. Here's the link if you want to go to that. It's hyperlinked in your materials. It was 2019 was the most recent data, and I've actually seen some data that shows that 77% is actually in the 80s or 90s now. But this is the most reliable data I could find for the most recent. 77% of US legal issues are unresolved by a lawyer. Okay? So again, I know math is complicated. We're going to do a little bit of inverse math here. So 23% of the market of people who know they have a legal problem are being served. That means the potential legal market is over $1.3 trillion. Okay? And those are people who know they have a legal problem, right? This is a family law conference. How many victims of domestic violence think that they have a legal problem? Maybe criminal? Maybe they don't think of it as a legal thing until they are ready to try to get divorced and get out of that situation. So these are people who know their problem is a legal problem. They don't necessarily, but not all people know that. So I actually think that's probably closer to $2 trillion of a market opportunity. But this is why I'm not afraid to teach every lawyer, at least in the US, in English-speaking countries, how to do what I do. Plenty of market opportunity, right? So really today, I'm here to talk about the ethics of not using AI, and what happens there. But let's look at this, right? And it's already been brought up. The ethics of using AI incorrectly, right, can result in sanctions, censures, disbarment, loss of trust, ruined reputation, disengaged clients, and more. And I would also go back to my earlier point that your clients might want to disengage you if you're not using the tools, right? But if you use it wrong, I'm going to argue today that you should be using it. But this is what happens if you use it wrong, which none of you will after today's presentation. So generative AI, what makes it generative? It generates something, right? Now, analysis itself, when it's actually analyzing something, that itself is not generative, but it still generates you a response based on the analysis that is, right? Because now AI is a term that's thrown out there, and frankly, GenAI and AI are basically synonymous terms these days, but in most situations, when somebody says AI, they mean generative AI. Now, when used correctly, it's going to revolutionize your practice, but it's not a source of facts or data. It's not a source of facts or data. This means you are not to use ChatGPT to do legal research, right? You are the source of facts or data when you're leveraging these off-the-shelf generalist tools. You can bring your own documents. You can bring your own data set. One of my favorite tools right now, Notebook LM Plus, is you have to bring your own data set in order to leverage the tool. And it's significantly more reliable because of that, right? Now, is generative AI perfect? No, but it's far less prone to errors than humans, in my experience. And it's more predictable. And it doesn't try to hide when it makes a mistake, like people do. When you're a lawyer using this tool, this is the single most important concept that you could take away from today's presentation. Because your GenAI tool must use retrieval augmented generation. And here's why that matters. RAG, for short, is when GenAI draws from a specific source of truth when responding to a prompt. So what does that do? It improves the accuracy of the response. So there's 3 different ways that AI gets you information. There's training data. That's the information it's been trained on. Think you need to take a constitutional law test in law school. So you read the case book and the materials, right? And you're learning that information. But then it's a closed book test. That's training data for AI, right? It reads the material, but it doesn't have access to it when responding. And the way that these models work, these large language models work, it works a lot like that. Like if you read a bunch of material, right? You were trained on something. Reinforcement training is the second thing, and that's when you see the thumbs up and thumbs down on these tools. That's where you're giving reinforcement training, and before they released these tools to the public to use, they had people in other countries doing reinforcement training. Yes, that's a right response. No, that's a wrong response. And that's kind of the reason why ChatGPT in particular is very much oh, I'm sorry, because that's how it was trained. But this retrieval augmented generation, it will go, you'll ask it a question or a query, and it will go and look up the answer, retrieve information, and augment its generated response before giving you an answer, right? So when you're evaluating these legal AI tools, these are does your tool use retrieval augmented generation is a really important question, right? So for your Lexis and Westlaws, and your VLexes, which used to be Fastcase, they are tapping into their database of case law, of treatises, of examples, of templates before generating you a response. That's really important in the world that we live in. I don't even use those tools. I use Paxton for reasons I'll explain soon. So what this does is it gets rid of mostly, if not completely eliminates hallucinations when it's properly leveraging this. Now, I'm not technical. My background is in philosophy and law, right? So I've learned as much as I can about this space. But the way that I understand it, it's not just as simple as connecting an LLM to a database. There's a lot more engineering that goes on in the background. And so there is still differentiation between these tools. It's not just I magically connect to a database of case law, right? But ChatGPT is not connected to a database of case law. It's answering you based on it's training data, so it's not going to be reliable, which is why you should never use it for legal research and ask it to check citations. You're just wasting your time. Sure, maybe it's been trained on cases, but it's not going to perfectly regurgitate them, just like you can't perfectly regurgitate the constitutional law casebook, and it doesn't have access to it when answering, right? Now, interestingly, the large language models don't have to be trained on these sources of truth in this database when accessing that information. But just like someone with a master's in English, which I'll say is ChatGPT, doing legal research, like if you are connecting it to a database, they're not going to be as good as a lawyer doing legal research, which is a legal-specific large language model or GenAI solution. So I put together this chart for you to try to understand that. So in the top left corner, this is going to be your most reliable AI tool when it comes to accuracy for leveraging these tools for legal research, for legal analysis, for drafting, for summarization, right? So you have a legal-specific large language model, and right now the only one that has at least publicly explained that they have this is Paxton AI. They've trained their legal-specific large language model on every U.S. state statute, federal statute, administrative code, millions and millions of legal documents, right? They've at least this is representations that they've made to the public, and they're connected to an AP to a database of cases and up-to-date cases, right? This is actually my tool of choice, is Paxton, for this exact reason. They're the only legal-specific AI tool that's out there. In the top right corner, you've got your VLEX, your LexisNexis, your Westlaw. What they are is they're called the GPT wrapper, which is like my next slide or two. And they're using ChatGPT to do the legal research, but they're giving it the data that it needs. So its accuracy is still going to be way better than a general tool that's not connected to the database of information that you need when doing your legal research. But it's not going to be as accurate as a lawyer, a legal-specific large language model doing the legal research, right? That has probably also read all the cases and has been trained on all the cases and could go look for it. Imagine if you had an open book test, but you've never read the material. If you're really smart, you might be able to find the answers, right? But if you've actually studied and read the material and you could go look for it, you're going to find it faster, and the likelihood that you find the right information is going to be significantly higher. So then what's the point of the bottom two categories as a legal professional? Well, in the bottom left category, that's when you're using both of them, that you should only be using these tools to do non-fact specific things, right? So I still like to leverage databases, even like directly, when I'm looking for a contract template or a form or something for drafting something. I don't ever like to start from scratch. AI is always going to be better at enhancing existing work than helping with the blank page problem. I will still spend a lot of time maybe drafting a first draft if I can't find something in a database, and then use AI to go in and change all passive voice to active voice, to shorten it up, to find what's the stronger argument or weaker arguments, right? So sometimes just the drafting things from scratch, whether it is or isn't a database in the bottom left corner, it's still going to be much better at doing things for legal specific type documents when having a database doesn't necessarily matter, right? So there was an example where I'm fractional general counsel to small business owners, ultimately. That's the simplest way to put it. And I needed to draft a company car agreement on behalf of the employer to one of their managers, giving him a company car. Well, that example was not anywhere in my database, but I know the provisions that need to go in it, right? So inside of Paxton, in the bottom left category here, there's no example that it's drawing from. But after about 10 minutes of going back and forth, I had a really solid company car agreement. ChatGPT would not have been able to do that, because I'm also communicating with the tool in jargon, in legal jargon, right? And it's specifically designed to do that. Again, going back to the contractor example of using the right tool for the right circumstance. And then the bottom left corner is it's still really good for a wide array of things. If you're already going to be filing something in the public record and you do like Claude or ChatGPT or Grok or whatever AI tool that's general purpose, you could still say, hey, look at this from the perspective of a judge, as a juror, as opposing counsel, and tell me what you think are the strongest arguments or weakest arguments, right? Like they're still useful for things like that. So GPT wrapper, I mentioned this. What this does is this provides a user-friendly interface around the tool. right? So rather than using ChatGPT to do legal research, well, your Westlaw, Lexis, and VLEX are going to design around those models, OpenAI's LLM, Claude, which is by Anthropic, and they're going to leverage these tools purpose-built for lawyers to use. So it's still really useful, right? Because it's built with lawyers in mind, or whatever industry. If you're a coder, there are tools like Lovable and Cursor and v0.dev, not relevant for this audience, right? But it just makes it more user-friendly, and that's okay. That's a good thing. Sometimes GPT wrappers get a bad rap, no pun intended. But this is good. So just if you hear this concept of a GPT wrapper, this is what it is, right? It's using other models for purpose-built activities. If anybody here uses Canva, like they have AI features now inside of Canva, it's not purpose-built for that, but it makes it a lot easier, right? I'm also going to point this out. So for retrieval augmented generation is the thing to take away. What I'm about to tell you here, this is how you want to think about using these tools when you start using them, right? Which is, again, it's just like emailing or texting with somebody, right? So this is really important, though. GenAI is like the smartest person on the planet. They're your assistant. They've read everything on the internet. They work for free, or for, like $20 a month. But in any event, even like your Paxtons or your Westlaw, Lexis, VLEX, they're going to cost more than $20 a month. But they're still far less expensive than hiring a human. And by the way, I don't think AI is replacing humans. I think AI enhances the work of humans. So if it used to take you 5 or 10 people on a team to become $1 million law firm, now you could probably do it with 2 or 3 people, right? So it's enhancing your ability to scale and do more work, right? So it's not replacing humans. It's just enhancing our work. But here's the thing about this AI. They're an entry-level worker. This is their first job, and it's their first day on the job. And it's like that every time you start a new conversation with them. Like, that's AI. So if you think about that, every time you start a new conversation in whatever your AI tool of choice is, just remember this context. Like, what are you going to do, right? You're going to give them a lot of context, right? Here's all these things. Like, just think if you had to bring a new associate who's fresh out of law school, or a law clerk who still doesn't know anything. You're going to have to, you're going to have to help it a little bit, understand the tasks that you're trying to give to it, right? You'd follow up. You wouldn't expect perfect from somebody it's their first day on the job. They're an entry-level worker. They're still the smartest person on the planet, right? But you follow up, follow up, follow up. It's not Google. It's not a search. It's a conversation, just like emailing or texting back and forth, right? Would you trust this assistant as a source of truth? No, of course not, right? And also, by the way, they're not socially well-adjusted, and they really want to please you because it's their first day on the job and it's their first job, right? So it's remember that. And again, the GPT wrapper of it all, actually Paxton started to do this recently, but the first mover was a tool called GCAI. And this was such a magical experience when I first saw it happen. I'm really glad Paxton is incorporating this now. But if you don't give it enough information, these tools designed for lawyers, General Counsel AI and Paxton AI are designed for lawyers, they ask you follow-up questions. Oh, wouldn't that be great? That's like a much smarter assistant than we just talked about, right? Because they're designed for legal professionals where facts matter. And the more clear you could be to the AI when giving it an assignment or a prompt, the better. So some of these tools are now being designed to ask clarifying questions. It's amazing. So that's the power of a GPT wrapper. Here's what GenAI is not. It is not a calculator. Right? 2 + 2 = 4 is an immutable truth, and once programmed, it always gets it right. That's called deterministic, right? So certain algorithms, calculators, the way we think about machines, we think they're deterministic, right? You input a question and you'll get a correct answer. But that's not generative AI. They're large language models. Language is all made up. We made it up, right? If I were to just spell out the word L-I-V-E, what does that spell? Somebody shout it out. L-I-V-E. Live, live, right? Different contexts have different pronunciations and different meanings, right? And actually, some of the video and audio AI tools get it wrong still when it's pronouncing those words, because what they do is is it's a probabilistic model, not a deterministic model. It's just guessing the next most likely word. And when it's just guessing the next most likely word only a few words out, it doesn't get context always right? But they're contextual machines, which is how the human brain works, by the way. Okay? So that's how you have to think about using these generative AI tools. It's like working with a human, going back to the earlier example, right? But this is why it can't be relied on as a source of truth. There has to be some sort of ground truth, like a case, like a database of documents, right? Or your own database. So general use versus specific use AI. What makes AI legal specific? Hopefully we all understand ChatGPT is not legal specific. It wasn't designed for lawyers to use. The vendor will tell you, we're legal AI. We're a legal tech tool, right? So is that enough? No, but it's a good start. And if it's legal specific, then the inputs, the uploads, the prompts will not train underlying large language models. Each user, each client, each file or notebook, depending, there's all different kinds of jargon and terminology that's used. Whether it's an instance or a layer, it will all be separate from the LLM and be replicated throughout the firm and per the client. Right? So every time I start a new file inside of Paxton, right, it's separate from all the other files. It doesn't train any underlying large language models. Only I could have access to it, just like with any cloud provider. That technology provider doesn't have access to my client files, right? They're going to have higher security, HIPAA and SOC 2, right? So what's really great about Paxton is I think just last month they announced that they achieved HIPAA certification. So that's amazing. I still I don't need to upload medical documents or medical records, but if it's that secure, and I was already using it because they've achieved SOC 2 compliance with confidential client information, because that's why that was what it was designed for, right? But you have to ask this of your technology vendors. And I'm not actually talking about all the tools today. There's an addendum to the deck that has all the tools. And then, the company reps, right? They can't get access to your prompt history. So if you don't know what SOC 2 compliance is, here's the definition. It's from a startup called Vanta. That's what they do. They help companies achieve SOC 2 compliance. Basically, it's just they have really good security, cybersecurity. So I've talked a lot about just general use AI, and there's so much to cover, so I don't need to go through all of this, but what I will say about the general use AI is here's some really good tools. Perplexity, in particular the Pro version that starts at $20 a month or $200 annually. I have not used Google for search for over a year. And I use Perplexity multiple times daily. There's an app, you can download it on your phone. It is an answer engine. You know when you're searching for something on Google and you open 20 tabs and you have to go through and you have to read all those tabs, figure out which one's reliable, which one's helpful, whatever? Perplexity just does all that for you and gives you a summary and citations. So you could click on the citation and you could go and still look for something. And I don't know about you, but I'm already starting to get some clients inbound saying they found me on Perplexity. And so it behooves you to, right now or very soon, go on, it's perplexity.ai, but there's an app, I love the app, and you could bookmark your findings, and you can have conversations with it. It's a generative AI tool, it's not just search and answer. So you could say, I was really looking more for something else, but my favorite prompt in Perplexity is tell me about blank, right? A person, opposing counsel, a judge, a company, the opposing spouse's company, something like that, right? And then you could ask follow-up questions, right? And they have a deep research function, which I actually say use sparingly when you're asking about people, because there's people with multiple names and it starts to get things wrong, but the Perplexity Pro Search is like the perfect Goldilocks zone. So you do that, then what I love about Perplexity, and why I really like Perplexity more than any other tool, is you don't have to worry about being a prompt engineer, if you've heard that term. You don't have to think about prompting. What the Pro version does, the paid version, one of the reasons I highly recommend it, it also does math. That's a whole other conversation. It does math and test it with equations or word problems you already know. So that's amazing. I found an AI tool that does math. But it takes your prompt and it makes it better. Yeah, isn't that great? Why aren't all these AI tools doing that? Well, Perplexity Pro does it. You do have to pay for it. It's only $20 a month, probably the best $20 a month you could spend. And what's cool is you could look at how it breaks down your prompt. Right? It might break it down into multiple prompts and rephrase it. And just by using that, if somebody's new to AI, I tell them to use Perplexity. Stop using Google for search, use Perplexity. And if you pay for the Pro version, you'll start to see, I should be asking my questions or prompting that way. So it's sort of teaching you as you're using the tool, which is really great. Highly recommend Perplexity Pro. Notebook LM Plus, I could give an hour-long presentation just on that. If you want enterprise-level protection and security, you got to pay. Right now, it's $12 a month. In July, it goes up to $14 a month. If you're a Google Workspace user and not using Microsoft 365, I have clients who use Microsoft 365. They're also now paying $12 a month just to get access to Notebook LM Plus. It's basically a bring-your-own RAG database. So you bring all your own sources, and if you're paying and you're an enterprise user and you're not using the free version, it's private, it's secure. The moment you sign into Notebook LM for the first time, it tells you that. It wants you to understand it was a tool built for research. I'm using it a lot. I'm building out every client file inside of Notebook LM Plus because in Q4 of this year, just like you share a Google Drive folder, you could share your notebooks in there, and now my clients could ask a Gemini-powered AI chatbot against their own file, and they're only going to get answers from their file. Not made-up stuff, not stuff from the internet, only their file. And it's a place where you could literally have a conversation with your documents, verbally. The feature's in beta, but I've been playing around with it with decks. Like, whenever I use a new AI tool, I always ask it questions I already know the answer to. I always ask it about documents. The very first thing I do is I upload a 600-something page franchise disclosure document that I've had the displeasure of reading several times before AI, and I ask it questions about it to see if it gets it right. So always test it with things you already know the answer to that you're familiar with. And the last thing, Descript is just if you're sort of doing your own marketing with your firm, Descript is sort of a great way to do that. I also use it instead of using Loom or Zoom to do screen recordings, and because you could record it and edit it right away, and it's all AI powered. If you could edit a Word document, you can now be an audio and video engineer in Descript. Really cool AI tool. So the legal categories, right? Here's all the different categories of AI in the legal industry. And I have examples of actual tools that fall into this category that we don't have enough time to go through in the whole presentation at the end of the deck. So you could find specific AI tools that say we do litigation, even personal injury, or just depositions. FileVine just acquired a deposition-only AI tool. Drafting specific, Spellbook comes to mind. Your legal AI assistants, some of them are calling themselves, the rebranding now is Legal AI Associates. Paxton is in that category. LawDroid is in that category. If you just want sort of an all-in-one tool and you don't want tools that do very specific things, look for your legal AI assistants. But sometimes, depending on your need, a specific, more narrow tool, it will cost money, but it will do a better job than a generalist, right? Even within legal-specific tech, doing legal-specific things in different categories. So here's some final AI tips. Written natural spoken language is the interface, right? Anybody could use it. You don't need to have technical proficiency to be able to use these tools. Context windows matter. Basically, the longer you talk, this is becoming less and less of an issue, but the longer you have a conversation with something, it starts to forget. Just like people, right? We can only keep so much in our short-term memory. The power of personas, I mentioned this earlier, if you're using these general tools, right? You are a judge, who went to Harvard and then practiced big law before starting in traffic court, moving them their way up. Like, how specific you get with, the power of personas and having it then analyze your legal documents could be really powerful. The future is agentic, which is just a fancy word for agent, meaning that these AI tools are going to start to do things for you. Like, I'm already sort of designing conceptually, using English when I say design, by the way. I'm just like making a step-by-step process of how I want it to do business development, right? Things that are non-billable, non-legal tasks, right? Really important. The AI tools, even if the last little bit of the presentation where I talk about, okay, so all this is saving so much time, and now you're using these tools and you're finding that hours of billable work now only take a few minutes, right? Even if you disagree with that and you're still going to bill by the hour, use this for all the non-legal tasks, all the non-billable tasks, right? But for me, right, like, I'm thinking about it in terms of leveraging it as a subscriber benefit, because my clients, just getting access is worth something, right? And then even if you're not using it client-side, think about how can we use this internally, right? So if you have access to Copilot, right, how could you leverage your internal firm data using these tools? And I suspect that's what Harvey is doing, but Harvey is really just for big law. So with all that in mind, I would say the era of the billable hour is over. Welcome to the subscription model, finally, right? How are we doing on time? I've totally lost track of time. 20-ish minutes? Okay. Before I get into the subscription model, and the end of the billable hour. I like to ask a question when I'm giving this presentation. A few questions, but it'll lead into the most important one. Is anyone here not billing time? Okay, so everybody's billing hours. Okay, good. No, this is excellent. The next question I have, and you have to be honest here, okay, with this one, really honest. If you really needed to, could you afford your own billable rate? Let's see a show of hands. Who could afford their own billable rate? Maybe 1, 2, 3, so like a handful, like 5 people raise their hands, right? 5 attorneys in a room of 300 something could afford their own billable rate. You can afford your own billable rate. So what does that have to say about the profession, that 5 lawyers raised their hand in a room of lawyers that they could afford their own billable rate, right? Looking at Model Rule 1.5, and I realize most of you here are from California, but I usually give this talk to any lawyers from anywhere, so I look at Rule 1.5. I'm sure there's some analogous one in your rules of professional conduct or whatever you call them. But at least in the model rules in comment 5, it says, a lawyer should not exploit a fee arrangement based primarily on hourly charges by using wasteful procedures. Well, the licensing bodies have not necessarily caught up yet, though some of them have. If you're not using these AI tools that I just told you about, or using AI tools at all in the way that I just explained, if not in the near future, in the eventual future, not using those tools and still billing hours, or billing hours that it used to take when it's actually saving time, you're putting your law license at risk. Right? This comment to your rule on fees, I like to call the implicit you must use technology rule. Does California have a rule of tech competency? I'm sure it does. Like you have to be competent in the tech? Maybe it doesn't. But what's fun about lawyers is we have rules in our rules of professional conduct that say you must be competent when using technology, but it doesn't say you have to use the technology. It just says you got to be competent when you use it. Well, I argue to you that this rule requires the use. So why the subscription model? Why not some other model? Because I hear this all the time, right? It's like, well, I can't just bill fixed fee. What if something goes, what if it takes a lot longer? What if it goes outside the scope? You know, I already told them what it was going to cost. Well, the longer a case takes, and if you're on a monthly or annual or quarterly, biannual subscription, that takes care of that problem, right? But ultimately, it comes down to thinking about the ethics of billing, right? Why use the subscription model or fixed fees or alternative fees? Because not using AI in your practice means you're exploiting a fee arrangement based primarily on hourly charges by using wasteful procedures. And sure, in the beginning, you could probably still use AI tools and still find hours to bill and maybe increase your practice's ability to bring in more clients. But when you're billing by the hour, you're serving only that small pie of people who could afford billable hours, or they have no other choice but to try to find a way to afford them, right? And when you think about the latent legal market that I talked about earlier, you're opening up the types of clients that you could serve, increasing market opportunity. And you will have eventually diminishing returns because the AI is only going to get better. It's already saving tons of time and it's only going to get better, right? So adoption of most legal tech eliminates billable hours these days. Client expectations have changed, right? What do you pay for by the hour? Anything? Other than a lawyer, maybe, if you had no other choice? Remote meetings are expected. You don't need a fancy office necessarily anymore these days. Even high net worth individuals respect their own time. They don't have to come into an office. It's really optional. Cost transparency is demanded, right? Now going back to that contractor example, imagine you hired a contractor to come over to your house to fix something or make some sort of improvement, and all they brought was a screwdriver and a handsaw, and they charge you by the hour. You want to pay them? You're like, where are your power tools? Where's your power drill? Where's your circ saw? You know, and then imagine they bring that, but then they start using a power drill to saw a 2x4, right? They're not trained in how to use the more efficient tools. Well, very quickly, it's not going to make sense for that contractor to bill by the hour when they're using power tools. GenAI are the power tools for the legal profession, right? So clients expect price transparency. And saying something's going to take 10 hours, they don't know what that means. Easy scheduling is expected, right? Now, there's a lot of things I talk about in this part of the presentation that even if you disagree with me on dishing the billable hour, although I think the GenAI talk hopefully convinced you that it's coming, whether it's coming this year, next year, 5 years, 10 years, whatever, right? Even if you disagree with me on that, all the technology I'm talking about today for leveraging an alternative fee-based structure could still be used in a billable hour practice, right? Things like scheduling, like Calendly or Acuity, Microsoft Bookings, Google Appointments, right? And instead of paying a staff person to handle that, you could allocate those funds towards your AI budget, right? But let's look at the benefits of the subscription model while I've got you here, right? Because even if, in particular in family law, and by the way, I've got some firms here that have totally ditched the billable hour in family law. They've all been guests on my podcast, Law Subscribed. Lester Law, E.L. Holmes Legal Solutions, Cary Center for Justice, Singular Law Group, Taproot Law, Evolve Family Law. I'm sure there's more. You know, there's no firms in this room that are doing family law and ditch the billable hour, but they're out there and they're growing and they're profitable, right? So it's definitely possible. But even if you disagree with me on the litigation side, think about all the things you do around maybe leading up to litigation, even after litigation, right? When you've got that marital settlement agreement, when you've got that divorce decree, you know, they've got to comply, right? Same thing is true in criminal law. You get somebody on probation, and they've got to comply with probation. Are they going to contact you if you're billing them by the hour? What if they're paying you a monthly subscription or an annual subscription, and you help them comply with their marital settlement agreement, with their divorce decree, right? So there's all different creative and clever ways that you could leverage the model, not necessarily in litigation, although I think you need a hybrid subscription plus fixed fee litigation model, right? But in any event, however you choose to adopt the model in your practice, you're getting predictable MRR and ARR. So what does that stand for? In the subscription economy, which there's a phrase for you to remember, subscription economy, that stands for monthly recurring revenue and annual recurring revenue. Even if only a portion of your clients, after, post-divorce, in whichever way it settles or resolves, want to sign up for your, whatever you call it, maintenance package, use GenAI to help you come up with creative titles for these things, these subscription packages post-divorce, even if you're just doing that, you'll start to discover the value and benefits of predictable revenue, right? But it goes both ways. So your clients now have pricing transparency and can budget and can predict. Even high net worth individuals like to know what something's going to cost and budget accordingly with their stockbroker or whomever, right? When you're not billing by the hour or tracking time whatsoever, your clients are not afraid to contact you or call you. They might already not be afraid to, right? And they're paying you for it. But what if you made that process even more efficient and customer friendly, like by having an easy scheduler tool so they don't have to play phone tag? Oh, and by the way, those clients who aren't afraid to contact you already, they're premium subscribers, right? They're top tier subscriber, right? So they get that extra access because you tier your access based on what somebody's willing to pay. This helps you foster ongoing relationships with clients. Now, I'm not a family law practitioner, though I've obviously interviewed them for my show. I have a lot of friends from law school that are family law practitioners. I've had family members and friends go through divorce, right? So I have a sense of what happens in this industry and the types of clients that you get. Some of them are business owners, right? Some of them, if they're not afraid to contact you, you don't just learn about them for their case, you learn about them as a whole individual. And if you have other practice areas, estate planning, tax, something that's related maybe to family law, or you have a robust referral network, now you're learning so much more about your clients that the revenue opportunities, but not just revenue, the ability to better serve your client, whether in your own firm or from another firm that you have a relationship with, right? Significantly increase when your clients are not afraid to develop a relationship with you because they're not on the clock. Have you ever had a client ask you, am I going to get billed for this conversation? Right? One of the reasons I wanted to start a subscription model is because I was getting clients calling in and I could resolve their legal issue within a couple of minutes. Just to open a file, because at this last firm I was with before I started my own firm, we had to open a file for every new matter. Like the staff time was going to cost more than billing them for the 2 minutes. Right? So how do you capture that value? And the subscription model is a way to do it, right? And when you're not billing by the hour, you're incentivized to be efficient and effective and adopt technology. So I was actually just asked at breakfast, how do you have all the time to figure out all this tech and the GenAI and stay on top of it? Because the faster I could do something, if I could automate a process that's manual, I'm making more money. The less time I spend on something, the more money I make. I'm going to say that again because we're in a room full of billable hour attorneys. The less time I spend on something, the more money I make, right? So that's the incentive, which means you could scale without more hiring, right? We're in a labor crunch in the legal industry. In particular, as other industries are moving to full remote, 4-day work weeks, little by little. I've been giving this presentation for a while, and I've been talking about the shorter work weeks. How are we as an industry going to compete, right? The UK now, I know it's a different country, but the UK, now there's like a whole coalition of 4-day work week companies, right? That's coming to the US. Who's going to want to work at a law firm or go to law school when you have to bill hours, right? When every other industry is using AI to be more efficient, right? So we'll overcome the labor shortage, right, with this model. So what is the result of this? Well, it reduces burnout. It improves attorney mental health and staff mental health, right? Attorneys are rewarded for efficiency. The vast majority of attorneys who have ditched the billable hour and are using the subscription model or alternative fees who come on my podcast are women attorneys and attorneys of color who are not rewarded for their efficiency at their firms. And so they have to go out and start their own innovative law practice where they're no longer billing by the hour. Right? I sort of already talked about competing with the 4-day work week. So in Arizona and Utah, alternative legal service providers are growing. Non-lawyer ownership is growing. Fee splitting is being allowed. I'm sort of in favor of a little bit of fee splitting if it's done in an ethical way, but I'm worried about the profession, about losing our monopoly on legal services. But there's so much market opportunity that we're not addressing that maybe we should lose our monopoly. How about we don't and we adapt our model, right? And it increases access to justice, and attorneys can make more money at the same time. How about that? So instead of thinking at everything from a micro scale, right? You know, did I win or lose on this matter? Or did I win or lose on this particular issue within a matter in terms of time? You think about things from a lifetime value perspective, like a portfolio of clients, not even a matter per matter basis or a client per client basis, but all of your clients, all of your firm. You start thinking about it as a business, your law firm, right? So giving you an example here, because I love to get challenged on this, so I get challenged a lot. Hopefully you have enough firm data that you can go back and you could look and you can see what was the most profitable case we had ever. How many hours did it take? How much money did we actually collect on that versus hours billed? And what you could do is you could, as an experiment, right? Maybe you do this with a client that you think would be more open to it first. But what you do is let's say you made, $360,000 on a case, because again, we're trying to do simple math here, right? So if you try to get your monthly price for that, you divide it by 3 for the year, then by 12 for the month, so that's $10,000 a month. And that's ultimately what you made on your most profitable case. Maybe you've made more. There are clients who would be willing to sign on for $10,000 a month, even if it's not going to be as complicated or as time-consuming as your most profitable case in this hypothetical. And that's just a monthly price. And frankly, I think that doesn't necessarily always get it done. I like to see a hybrid with litigation-based, because I actually started in litigation before I moved into the transactional general counsel space. So I originally designed a hybrid fixed fee and subscription model when I was at an insurance defense firm. I'd like to see, and you see this sometimes, there's like an initiation fee to do something, to get started with a new software tool or gym membership or some other things. Like you have to pay a higher fee up front, and then there's a lower monthly price, right? And where you see the most success in the divorce cases, and every jurisdiction's a little bit different, is what I've seen these lawyers do is they segment it, right? There's pre-litigation, and that's a monthly price. And then you're in litigation, but you're pre-discovery, and that's a monthly price. Then you get into discovery, and then you get, right? So like at each segment, the monthly fee goes up, or there's another initial fee with like the smaller monthly fee being continuous. The problem here is it is a little complicated, right? it requires you to think. It's not complicated once you spend some time thinking about it, but the billable hour, if you think about it, is just a really lazy way to do business. Well, it took this long and it's worth this much. There you go. You don't have to think about it. Lawyers, and I'm going to pat myself on the back here a little bit, are some of the smartest people I know. And if you had no other choice, right? Like, it's not in the slides, but I used to posit, let's pretend your licensing body says you have 1 year from today, the billable hour has been deemed unethical, and you can no longer bill by the hour. What would you do, right? You had no other choice. You would actually think about your business model. I know you didn't learn about your business model in law school. I didn't. You never had to think about it, right? So if you start thinking about it, you're going to come up with some really, really clever and creative ways, and the technology makes it easier than ever to implement it. Like, now is the time that alternative models can thrive. There is a legal tech tool called AltFee. I think it's altfeeco.com. It's actually not in the slide deck, but that's their whole business model, is help lawyers with this pricing, because it's not as simple as the billable hour, but it can be more profitable. But when you think about your cases, the point of that was when you think about your cases in terms of lifetime value, you're going to spend some more time on some cases than others, but in the vast majority, what you're going to start to see and what the data is starting to show, of course, it's still mostly anecdotal because there's maybe 1,000 lawyers using the subscription model out of the 1.3 million lawyers in the US, right? But it's growing, is that more often than not, just like any subscription model for any other business, not every single type of case is going to take more time than billing it at your most profitable case on a monthly basis. But clients like pricing certainty. So when you think about it in terms of lifetime value over the portfolio of your cases, you're going to be significantly more profitable, potentially, if implemented well, than you could ever be on the billable hour, because there are only so many hours in a day that clients are willing to pay, right? So market opportunity for institutional clients who want to cut costs. Think about your highest net worth individual you did a divorce for. How much happier do you think they would have been if they could budget a monthly price, even at a premium, right? But going back to the latent legal market, there's a blue ocean of market opportunity for clients previously priced out of legal services. A great thing in the subscription economy, which I don't talk about here, is good, better, best pricing, but there's also do it yourself, do it with you, or do it for you pricing, right? Think about all the data that you're sitting on for years or decades of family law, history, cases, motions, briefs, treatises, everything, that now there's a way to even productize a self-serve version. Hello Divorce comes to mind, right, as something like this. The technology exists now that even your law firm could offer a product like that, right? This allows us to compete with the LegalZooms out there, but we are actually giving legal advice, because LegalZoom is not a law firm, right? So how do you adapt it? There's the pure subscription model. They pay a fixed monthly rate. And I've seen firms do this. And you know what I've also seen some firms do? I've seen them literally ask their client, what's your annual budget for this? How about you just pay me that every month, right? And now the law firm is incentivized to be as efficient as possible within those constraints, right? And if you properly scope what they're getting for that monthly price, and you have different tiered levels based upon their actual needs, sometimes it's amount in controversy, amount of the estate, right? If they're getting divorced, I've seen that in probate too, like what's the value of the estate? And that plays a role in the monthly price. Subscription and flat fee or fixed fee, which I talked about before, I really like to see this model. And while I haven't seen it implemented in the family law space, I've seen in other types of litigation a success fee if it resolves sooner. That goes down the longer the case goes on. So now you, the lawyer, are financially incentivized to get to resolution faster. Because even if you can make more money over the course of a case taking multiple years because you're using the subscription model, you can make a decent chunk of that immediately if you're able to reach a settlement or resolution. So aligning these incentives and having important money conversations with your client is really important in the subscription and flat fee space. There's subscription add-ons, right? So if somebody's in a do it with you or do it themselves type model, but now they want you to come in a little bit more in certain instances, then there's opportunities for subscription add-ons. So for me, if I'm in a pre-suit situation, because I still will not do litigation, I have a $200 a month negotiation add-on fee for a dispute that somebody enters into that they want me to start negotiating on their behalf. And then if we settle and resolve it, it's $50 a page for the settlement and release. and then the $200 a month comes off, and they're back to whatever they were already paying per month, if they weren't paying a higher level subscription that already bundles in negotiations. Right? This is going to be different for practice areas. Transactional is different than litigation. And the pricing, I have so much fun with pricing when you start coming up with this stuff. And other than just thinking X amount an hour, you could actually start getting pretty creative and clever with the pricing. So we only have a few minutes left, and I do want to leave maybe room for a couple of questions. I am here until 4 p.m. before I leave the hotel, so I'm happy to also talk to people when the conference is over. But here's some quick examples, right, which is maybe less relevant for this audience. So fractional outside counsel, trademark space, document marketplace, right? They're just paying a fixed monthly price. They get scoped legal services. If they want a different scope or a greater scope, they have to pay a higher monthly price. Pure subscription model. These are my favorite clients. And what's nice about this is you could get them up the subscription tier depending on how much of your services they're using and they need, right? And having a clear way in your engagement agreement that you could move them up a subscription level or down based on the amount of services that they require from you is really important, right? Think about, again, going back to the contractor. They give you a quote to do the work, and then they discover mold. Well, that wasn't contemplated, right, in the quote. So in their agreement, there's you could have a change of scope conversation, and we should be able to have that too. So make sure that change of scope conversation clause is in your engagement agreement. Subscription and fixed fee model, I think this is the best model for litigation-related work, right? It's also good for corporate formation, like one and done things, right? Real estate, other transactions, right? I mean, I'm sure with the family law, in fact, I know for a fact, because I do real estate, that I've had to do real estate transactions related to a divorce. So this is one of these other tangential related areas to family law, right? Estate planning. The way to think about it is, if you could totally unbundle all of your services and all the value that you actually provide your clients, and the value is not the time that you spend, the value is the results or the problem avoidance. Your clients are not buying your time, they're buying what you're doing for them. You're getting them out of a sticky situation, right? Criminal defense is another area. So how do you price it? You keep it simple, right? No more than 3 offerings at a time. Give options of different tiers and different levels, right? A low accessible price for the market you're trying to serve. And again, that could be a lot of different things. I know a sports lawyer in California. I think he's in the LA area. His name's Brandon Leopoldis. And he represents bench warmers, but they're professional athletes, and they're making, mid 6 figures. So his monthly subscription to them, his starting price is like half their Range Rover lease payment, or half their, second, third condo payment, right? It's still like a nice chunk of change, but he's contextualizing it for the market that he's trying to serve. And then you could offer subscription add-ons. Right? And again, there are examples of this. I don't have enough time to go through all the examples. But when you sell your higher level subscription packages, you're bundling these unbundled value back, these unbundled values back together. Right? And what that does is it helps sell the higher value of the subscription. So you can see my website for examples, for this particular market. It's not necessarily going to make too much sense, but at least you could see what one lawyer does. Like my subscriptions start at $20 a month and $50 a page because I'm trying to get the types of clients that have been long unserved by attorneys. Yet my favorite clients are institutional clients who are sick of paying billable hours. How about that, huh? $50 a page for drafting an analysis. Now that actually scales incredibly well. I haven't seen it tested in a litigation space, but I have seen some other lawyers be inspired by what I do, and now they're charging per page. Somebody knows what a page is. A customer who's paying for a page, they don't understand what 6 minutes is and why that took 6 minutes, right? And $50 a page scales incredibly well. So when I represented a comedian who was getting an agreement with a comedy club, who's getting paid $1,000, he was willing to pay $150, $50 a page for me to advise him accordingly on that contract. And then when I helped a physician who was moving from one practice to another with 30 pages, I made a decent chunk of change on that one too, right? So it's really interesting how the per page pricing scales. So if you really wanted to see all my prices, that's the link. And I see I'm being booted off the stage here. So here's the technology that you need. Again, everything is in the addendum. Some final tips are, once you stop billing by the hour and you start using subscription, it's easier to understand what technology you could afford because you have that monthly recurring revenue, right? Here's my contact information. Feel free to reach out.
LinkedIn is probably the best way to get in touch with me. Thank you, everybody.